Hey, all persons like to do fully on board justice of the Appeals Court of Boston. Draw near, give your attendance, and you shall be heard. Do I see the court is now open. Please be seated.
Good morning, everybody. Welcome to the Appeals Court. I am Justice Rubin, and I am very lucky, and you are very lucky, because I am joined today by two outstanding colleagues. To my right, Justice Englander. To my left, Justice Brennan. We will be hearing a single case this morning, which is number 21-1096, Lewandowski versus Civil Service Commission. And the rules here, if you're unfamiliar with them, are 15 minutes per side. There is no rebuttal. And we will hear first from Attorney Kiley.
Good morning, Justices. May it please the Court. My name is Dale Kiley. I represent the appellant, Gregory Lewandowski, who is a lieutenant on the CHARLTON Police Department. And I had represented Mr. Lewandowski from the moment he had gotten when he received a letter from the chief saying that he was under investigation up through a Superior Court appeal of the decision and today before this court. In the civil service, in the first instance, failed in its legislative mandate to safeguard individual rights of Lieutenant Lewandowski, and erred in a way that materially affected the constitutional rights of the appellant when it failed to preclude investigative counsel from the proceedings. It refused to order production of materials that were produced by investigative counsel during the investigative phase. They refused to review the email that was dispositive of a pretextual nature.
What showing do you have to make to get a judge to do an in-camera inspection of asserted attorney-client privileged communications? How high a burden do you have in the trial court, or not just you, but anyone have in the trial court, to get a judge to look in camera at something that's claimed to be privileged?
Well, in this case, in the administrative hearing, the commissioner for the Civil Service Commission stated on the record at the time we were discussing this issue that he has done it numerous times in the past.
I don't care about that. I asked you what the standard is. What standard has to be met? You can't just go in and say, there might be something in this, Judge. Could you look at it, right? You have to show something.
Correct, Your Honor. In this case, the communication wasn't privileged at all. That's the whole...
You don't know that. You haven't seen it. You don't know what it says.
We don't know what it says, and all we have in response to all the facts that were presented, for instance,
Well, hold on. I mean, the communication is as I understand it, from the record that we have, is a document that came from the police chief to town council, right?
Correct.
Did you have a privilege log or anything like that?
No, we asked for the communication because it was sent...
You asked for the communication. They refused to give it to you on the ground that it was privileged. It was an email from the chief of police to his lawyer, right? And
Correct.
the lawyer, the only evidence, as I understand it in the record, is the lawyer said, and it asked for legal advice, right?
No, Your Honor, I respectfully disagree. That's not the only issue on the record. The email came during an investigative phase when counsel was being used as an
What do you mean during the investigative phase? As I understand it, it was before, it was in conjunction with the decision to, I think, suspend Lieutenant Lewandowski pending further investigation, right? It was at the beginning.
He was sent a letter. Lewandowski was handed a letter by the chief. It says, I am investigating matters. I have not made a
And when does this document that you want to see, when does it fall in relation to that letter that was handed to the lieutenant?
That day.
Okay. So it was right at the beginning.
Saying that he was under investigation. I've made no determination, no disciplinary action. I found no reason.
Why is there any reason to believe that a letter from a client to his lawyer, which the lawyer has represented in open court, contained a request for legal advice, is not subject to the attorney-client privilege? What is it in the record that tells us that? Because you come on very strong in your brief about how this is going to be very critical to your case, and it's not privileged, and the only information that we have indicates that it is privileged.
It's a self-serving statement by an attorney saying
It's always
privileged.
self-serving. Everyone's statement is self-serving, right? I mean,
Well, the standard, Your Honor, is that the person claiming the privilege must prove that it's privileged.
no. Through in-camera inspection, they have to prove it, or you get to see anything. I come in, I'm the lawyer, and you say, I'd like to see that stack of documents you got there. And you say, these are attorney-client privileged documents, you can't see them. And you think that you get to say, prove it, and if I can't, you get to look through my file? That doesn't sound right to me.
Well, no, Your Honor, but that's not what happened here. I didn't ask to see them. I didn't need to see them. I asked the Civil Service Commissioner to see it because...
Kindly on that, I'm sorry.
No, go ahead.
So on that, you ask, the town objects, the commissioner or the quasi-judicial officer says, well, I'll take it under advisement. Why don't you talk about it and get back to me? Isn't it incumbent on you then to get back to the commissioner, and if not, then you've waived the issue? Why haven't you waived it?
Well, because, Your Honor, I had asked 6 times previously, and...
During that hearing?
One time previous during the hearing, and it
Okay.
was actually allowed. I asked for the email.
As I read the record, you asked for an in-camera inspection, not asked for the document. You asked for an in-camera inspection. The commissioner says, what do you say to the other side? The other side says, well, we object to turning it over. And then it's left hanging. Why is it not incumbent upon you as the person seeking the information or seeking the in-camera inspection to press that issue? And absent that, why haven't you waived that issue?
Well, so first, Your Honor, it was asked, if you look at the Record Appendix, Volume 2, 447, so the transcript page itself is 442. I asked for the email. I was questioning Chief Maxfield on an email that he sent to
All
counsel.
right, what was the exact page?
It's the Record Appendix, Volume 2,
Right.
447. 447.
447. Thank you.
And then the transcript page itself is 442 on that Record Appendix document. I asked the chief for the email. There's no objection from counsel at that point, and the commissioner says he'll leave the record open for the email. So it was already addressed. He was going to leave the record open for the email. There was no objection by the town. That was actually the 3rd or 4th time that I asked for that document in the proceedings.
That precede the time when your opponent says you asked, there was an objection made on the record to the commissioner, and the commissioner, I think, then says to you words to the effect of, why don't you let me know what you want to do? Right? Is that the last time in the record we're going to see a reference to that?
No, Your Honor. The last time there's a reference to it is in lieu of final arguments. So he wouldn't let us make a closing argument. He wanted us to submit a document for disposition of the we were supposed to make our findings for him and give him something to do. That was the form of a closing argument. And I spent a page and a half in that closing argument document on this issue. So that's the last time in the record that you'll see it.
Can I ask you a somewhat different question? We obviously have to figure out the waiver question, and it seems a little complicated to me. You obviously asked a bunch of times. It's a little odd for the judge to say, even though you've asked, why don't you think about it and ask me again? That's a little odd. So we'll have to sort that out. Let's assume we get past that hurdle. The whole premise of your argument is that a pretextual firing, even if it's for a genuinely good reason, is impermissible. So, just to sort of cartoonishly create an analogy to this, the boss hates the employee, wants to get rid of the employee, but they're protected by the civil service law and can't. And then one day, the employee does something that a bunch of other people have done, and the boss didn't care about that. But it's something bad. It's stealing money from the government, or vacation days, or whatever. And so he says, the boss, hey, you're fired. And facts are found later, yeah, stole the vacation time, good enough reason. Your position, I take it, is doesn't matter if the real reason was animus toward the person. What's the best case you have for that proposition? Do you have a case that says that?
Well, I believe that mischaracterizes my true argument. I believe that everything that happened here was done by the chief or the town in order to develop the circumstances to make the pretextual. So when you go back to the beginning, the whole sick leave audit debacle occurred in December, a month and a half prior to the time where they discovered there's 2 longevity pays.
And then they started looking through every file drawer and every, back corner of an office and looked at whatever documents they could find, and they found something. Or at least, maybe you dispute that, but at least the Civil Service Commissioner found that they found something. A legitimate reason for firing someone that would, barring anything else, be just cause. And my question is there a case that says you can't do that?
I have not found a case on that point, but again, I believe that that is not the view that we have taken or that we've tried to.
Well, then what is it? Because I had a similar question to Justice Rubin's question, which is, what is exactly your argument for why this should be overturned? Is it that there's been a violation of the state civil service law because the finding of just cause was wrong? Or is it a constitutional argument, which I see playing around your brief, that somehow your client has some sort of due process right that was violated here? And if it's the latter, I'd really like you to articulate it for me.
It is the latter. So his right to employment and to not be fired for just cause is embodied in the statute for the civil service law. That's what they're designed to. So he has a constitutionally protected property interest in his job, cannot be fired for just cause.
Without just cause.
Right. So, here.
So was this a substantive due process argument that somehow one of the constitutions, I guess the U.S. Constitution, provides us with a standard for deciding when you can be fired? Or is this a procedural due process argument? And if it is, what process didn't he get? He went right through exactly the process provided by Massachusetts law.
Well, he was deprived at every turn by the Civil Service Commission of providing a defense for himself. In my pre-hearing report, I specifically asked to exclude investigative counsel from the proceedings as a material witness because he provided investigation, he was at the deposition, the 40 questions that they asked.
How was he deprived of providing a defense for himself because another lawyer sat in the room?
Well, because that lawyer provided investigative assistance to the town. So everything he did during the investigative phase is not privileged. And I believe I cited...
Did you call him as a witness?
I was precluded because I asked for it as a motion in limine at the pre-trial hearing. I asked for a number of things. I asked for documents that would show what counsel actually
But I
did-
guess I'm still back on my question, and I think it's reflected in what Justice Englander said too. So what? Okay, so you put him on the stand and he says, oh yeah, I acted as investigative counsel. What did you do? Well, I went through all the records and I saw that when he did the sick leave, he only used the computerized ones, and he knows full well which days he was sick, and they're in a written log, and he didn't put them in, so I thought, aha, he lied. And so then I issued 40 interrogatory-style questions and turned to him. And after seeing the answers to them, I concluded he lied, and that's a good enough reason to fire him. How do you win? The judge found that he lied. So how do we reverse that, even if he was investigative counsel and he did act as an investigator and they went after your client because of personal animus? I still am not sure I understand why, if there is just cause for the firing, how we would ultimately reverse.
Because he's entitled to a fair and impartial investigation, and he did not receive a
Wait, I'm not sure I even know what that means.
Yeah.
Investigations are done by executive branch officials whose job is, in lots of cases, let's take crime, to ferret out crime and stop it. So they get suspicious about someone and then they hang around his house and look through his garbage and do 100 million other things that they're totally allowed to do and that's proper, but no one would say, I don't think, that it's an impartial investigation, right?
In other words, there's a distinction between a fair and impartial investigation and a fair and impartial adjudication. I understand the point that there is, at some level, a constitutional right to, you know, I mean, that part of due process is that this is going to be fair. You're going to have unbiased decision makers. You're going to follow a process that's set forth. I'm talking very generally. But that does not translate to a fair and impartial investigation. Those two are different, right?
Not under the civil service law. If you're firing somebody for just cause, the investigation should be fair and impartial into wrongdoing.
Well, it
And
should be
that-
fair. I mean, I guess impartial.
But are we talking about the
Impartial.
That's why I asked the question. Are we talking about the Constitution, or are we talking about state law? And I'm still struggling with which one is the basis for your argument. If your argument is state law was violated here, they didn't follow the process properly, I understand that, and then I can evaluate that in that context. If your argument is that there was a constitutional due process violation, I'm struggling. That's why I've been asking the question.
Well, because, Justice Englander, I believe they both were implicated here. The state law embodies the protections that we have under the Constitution.
No.
For
No, the state law gives you a property right and kicks in the constitutional due process requirements. But the state law doesn't tell us what the Constitution protects. The two are different, okay? I mean, I know a bit about this, so.
I'll defer to you.
Your time has expired, but if there are further questions, no?
I don't.
I see none. Thank you very much. Excellent argument, interesting case. We will hear now from Attorney Peliquin.
Good morning, Your Honors. May it please the Court. Leo Peliquin for the Town of Charlton, and in this instance, the Civil Service Commission defers to us to defend the decision, as the Court knows. Your Honor, the premise of basically depriving the town of its attorney-client privilege in their counsel, with their counsel, is bald-faced allegations, unsupported by the evidence, that counsel was hired to do a sham investigation in concert with the town. There was some type of conspiracy involved, and therefore...
The strongest evidence, I think, that Lieutenant Lewandowski has is this list of interrogatory type questions that the chief, I gather, communicated to the opposing party. It's not an unreasonable inference that those were written by a lawyer, because they're in the form and style of interrogatory questions. Does that mean that some of the communication with the lawyer was not attorney-client privileged, if we assume that the lawyer wrote those questions?
Of course not, Your Honor. Attorneys hired to give advice often give guidance to their clients. Clients often run documents by them to ask their input on them. Legal reasons to ask their input: what can you ask, what can you not ask? Documents often address whether or not the employee can answer voluntarily or is compelled to answer.
And so what is this category that I had not heard of, frankly, until this case? Investigative counsel doing something other than providing legal advice. What is that?
Well, I wasn't hired as investigative counsel. I was hired as special counsel. Municipalities across the Commonwealth hire special counsel for a number of reasons.
Of course, but that's not my question. The question is about functionality. It's obvious you're hired as counsel. You could just be called counsel.
Correct.
I called an attorney and hired him, whatever it is. But the question I have is, your brother suggests in some of the cases he cites suggest that when an attorney is acting in an investigative capacity, that the communications may not be within the privilege. Do you understand that to be the rule?
Well, the cases that he cites do not show that they were hired. If they're hired as investigative counsel, that's different if they're doing the investigation. And the City of Boston case is a classic example of that. Initially, counsel there was trying to defend the city against a potential MCAD claim.
Yeah.
But what it turned into was doing interviews and having members of the department at the interviews, and those interviews ultimately contributing to a decision to suspend the employee.
And why isn't that all privileged?
That's not privileged because in that instance, the role changed. Now he became the investigator, and the city was determined to have waived the privilege as a result of that.
He became an investigator, but it's still a lawyer asking particular questions because the lawyer's specialized knowledge allows the lawyer to know which facts are relevant and which ones aren't.
Because they use the lawyers, it's because they use the information, right. They expressly use the information developed by the lawyer to make the decision with respect to the opposing party, right?
Correct. They use that information.
Once they do that, once they have used that information, then they can no longer protect whatever it is that the lawyers communicated about that.
Correct. But
and why isn't this maybe that case?
Well, it isn't that case because the chief did the investigation. He developed the information. If they wanted notes and they wanted to talk to someone about their notes, it was the chief they could have.
Your brother's argument is hand in glove with the lawyer.
Well, an attorney can give advice as to how to do an investigation.
So if you write out the questions for the chief, but you don't ask them yourself, is that the distinction you're drawing?
Well, I would not assume that happened.
Theoretically.
But say, theoretically, the chief does a list of questions. What do you think of these? Can I ask him these? Can I make him respond to those questions that I asked?
Well,
the lawyer's there to give advice.
We've all been lawyers. More likely, either the chief says, I don't have the first idea what to do, and the lawyer gives advice, or maybe the chief drafts 8 questions and they're completely off the mark because what you're looking for is just cause, not, you know, did he spend time in a donut shop with someone or whatever, and the lawyer edits them, including adding additional ones, making sure there are no gaps between them, you know, so that all the elements needed to build a case or determine if there is a case are there. At what point does that become doing the investigation rather than providing legal advice?
It's providing legal advice, Your Honor, because in this instance, a fair and impartial investigation is suggested at the root of all this, so that the attorney is there to say to the chief, at some point in time, you're going to be, if you impose discipline here, you're going to be subject to questioning about the nature of the investigation. We have to make sure that it's done legally, that it complies with due process. So the attorney is perfectly within rights as counsel, and the chief's perfectly within rights as client to be able to accept that advice.
Is your opponent correct that he asked for this particular, there's one document that I'm aware of, I'm really not, I guess 2 different categories. A letter from the chief or an email from the chief, as well as your billing records that have been requested. Is it true that with respect to the email from the chief, that it was requested multiple times?
I guess it's a matter of semantics. He requested it during the course of the hearing. If he wants to count the time that he asked the chief that there was an email, it would be 2 times. What happened was the Civil Service Commissioner, Chairman Bowman, very experienced, said, okay, I'll hold the record open for it. Then we got back to him in the record. That was the colloquy with
And I apologize that I haven't read it directly,
Okay.
but is Justice Rubin correct that and this is just my fault, I should have read it,
Yep.
and I meant to, that it's words to the effect of, Mr. Lewandowski's counsel says, Lieutenant Lewandowski's counsel says, we'd like that email, and you object, and the commissioner says, well, why don't you let me know whether you really want it? Is that?
Well, a little bit, but I understand, it's a big record.
Why would you object to in-camera review?
Because that is one step toward depriving the town of the attorney-client privilege. The in-camera...
And what showing has to be made to do that?
All the showing that the town had to make was that it had an attorney-client relationship.
No.
No. that's
What
not-
showing does Lieutenant Lewandowski have to make?
Oh,
When you claim privilege, that's not a sacrosanct, the game isn't over. If they can show something, they get an in-camera hearing, right? We know that's true because the crime-fraud exception allows an in-camera hearing. You have to show a certain amount of evidence to get that hearing. What do they have to show?
well, they would have to show a basis, and there was no basis here except for wild speculation, because Lieutenant Lewandowski was in trouble, and the town was investigating him, the chief was investigating him. The wild speculation that special town counsel was hired to come in and work with the chief and the town administrator. to
Many
do a
other
she-
people who engaged in similar behavior were not disciplined. Is that enough?
No, that was not enough, Your Honor, because this was at the point of the investigation. That,
It appears that the lawyer wrote these investigative documents. Is that enough?
not enough. Attorney-client privilege.
Is your
Yeah.
concern, I think I get it, and it took me a little while to get it. Your concern with in-camera is that this is also the decision maker. So, if I had a case that was going to go to trial, somebody wanted an attorney-client privilege, it was frequently the case that somebody would say, put that in camera, and if there was reasonable doubt, it would go in camera. But the judge isn't going to be the ultimate decision maker. The jury is. Here he is, and you don't want to show him what it is that you said to your client. Or
the
vice versa in this case.
Well, Commissioner Bowman himself was reluctant, as you can see
Yeah.
from the record.
Yeah,
He was
okay.
reluctant and once you go down that email, what about the 5 emails before it and the 6 before that?
I'm guessing you can get someone else to do the in-camera review if you wanted. I don't know if there's law on this, and it's
There
not a
is, yeah.
courtroom.
That's the way it's
But I would think you could get someone.
Well, he was saying he was going to do it, but he was reluctant to do it, and he said to counsel, you should think about this. He didn't say that to me because I had
What
already
does
said
that
to him.
mean? I've never heard, is that denied or allowed? You should think about this.
Well, it's like status quo. It's not in, and I'm not putting it in. If you want to show me something more...
If you want to ask again, my rule in this courtroom is twice.
Well, no, I think it's more than asking again, Your Honor. The record is clear that counsel never at any time provided anything more than the request. That was an opportunity to go back. He claimed case law, civil conspiracy, all that stuff. He never provided anything else. He was silent. That whole hearing, he was silent, the hearing that occurred on June 12th, all through that. The commissioner didn't
Was
even
this
bother
email
to...
ever filed under seal or impounded or anything like that?
I'm sorry, Your Honor, I missed...
This email, was it ever filed or is it in the record in some impounded or sealed form?
It's not, Your Honor. It's not.
I'm still struggling with what the basis for his argument is, in part because I need to understand this. In the civil service law, there's a state law right not to have the decision as to just cause based on bias or perhaps, a decision that's not on the merits for some reason, right? I mean, how is that articulated in the state civil service law? In other words, if I'm the police chief trying to decide whether or not there's just cause to discipline a lieutenant, I need something that comports with my policy manual, not because I don't like the guy or because, right? How is that articulated in our state law?
Well, it talks about political bias, undue influence for political reasons. And that argument was raised by counsel.
Well, does it actually use the word political? Because that's much narrower than I understand the argument to be made
I think
here.
the word political is, if it's not in the state law, it's in the cases that construe this case law. And that's how the commission has interpreted it. And Commissioner Bowman's own decision relates to how they are obligated to do some deference to the employer unless there's evidence of that type of bias.
But so wait a minute, I don't really understand. So your view is that if an employee is stealing money, but the real reason is political bias, why you want to get rid of that employee must be retained even though they are a thief. Is that right?
No, I think it's the opposite. I think if the reason given is a sham for...
No, if it's a fake reason, okay, but I'm saying they don't care if the employer doesn't care about this kind of behavior ordinarily. There's 20 other people doing the exact same thing, and he turns a blind eye to it or approves it or whatever. Turns a blind eye, let's say. But this guy, he hates him for political reasons. He was appointed by the old chief or whatever, and so he decides to use against him something that's genuine wrongdoing, but that he's never cared about in any other case. Retain or fire?
Well, it's not that case, Your Honor, because
I
in
didn't
this
ask
case...
you it was that case, the hypothetical I'm giving you.
If that comes up and it's shown that others were given leniency or ignored, then you have a disparate treatment argument, and you would prevail at the Civil Service Commission.
Disparate treatment doesn't mean equal protection. It's a specific thing in the Civil Service Commission, and disparate treatment is not permitted. Is that right?
Well, disparate treatment, I think, is a prong of doing it for political reasons.
Yeah, but okay, so this is helpful, and I understand. Well, I think what Justice Rubin's getting at, and he can correct me if I'm wrong, is does disparate treatment overcome an actual just cause reason for termination?
Well, it's similarly situated individuals should be treated similarly. That's the disparate treatment principle. In this instance...
And it's enough to overcome... Suppose we have, and this is purely hypothetical, suppose we have a police chief who has overlooked the fact that he's got 6 lieutenants who are stealing time, okay? And then he decides to go after one lieutenant. You know what? You're stealing time. All right?
That would be
Civil Service will put that person back in because that's disparate treatment? Because 5 others have been allowed to steal time?
I've never seen that case, Your Honor, but with a police officer in particular, I would argue that any officer stealing time at any time because of the standard of conduct expected of them, disparate treatment should not prevail.
But we don't have something on that. Because that, frankly, that's the subtext to the argument being made by your opponent. Well, is that he should be reinstated because other people were allowed to do this. Now, I've given a harsher set of circumstances, but that's basically the argument.
But that wasn't the only offense, Your Honor. Commissioner Bowman did decide that to fire him for taking the longevity he knew he wasn't entitled to, he would not have fired him for that basis alone. But he went beyond that.
I understand.
He lied about the vacation time. He lied in the sick leave on us. He engaged in a lot of
They all can fall into the same sort of, anyway, okay.
Your time has expired. This is a very interesting case. Thank you both for excellent arguments that I think have sharpened the issues for us. The case is submitted as we were sitting on only one case today. That also means that our session for the morning is concluded. I'd like to thank the court officer and the rest of the staff for their assistance, and we stand in recess.